Okay, well, according to my list, there's 40 odd people already logged on. So let's make a start. For those of you that don't know me, I'm Hylton. I'm one of the barristers at Park Lane Plowden Chambers that specialises in personal injury and clinical negligence work. Today, I'm going to give you a short, somewhat practical guide to drafting agendas ahead of discussions between experts. The whole thing is definitely going to take less than 30 minutes and maybe even closer to 15. This format makes it a little difficult to ask questions. So once we're done, if anybody does want to talk about anything, you can find my email address on my profile and don't be shy. I want to start just by setting the scene a little bit and explaining some context as to why I've chosen to talk about agendas ahead of joint discussions. I made a point of trying to read NHSR's annual report. If you ever get the chance, I'd recommend it. It's very accessible. There's lots of interesting information there, and it's presented in a way which is very easy to digest. There's lots of takeaways from it, but one of the standouts is that whilst the number of cases reported to NHSR continues to increase, at the same time, the percentage of cases which settle early is also increasing. Now, that is explicitly part of a conscious strategy to drive down litigation, with the laudable aim of keeping patients and healthcare staff out of court. Now, we know this instinctively, and we often talk about certain things like litigation risk, CFAs, other funding models, QOCs, ADR, and Part 36, and the role that that plays in driving down litigation. But I don't think we often talk about the role that discussions between experts plays in keeping patients and healthcare staff out of court. So what I wanted to do is offer some practical advice about how to best go about that thing. Before we launch into some tips, I think it's always a good idea just to look at the rules and remind ourselves what we're talking about. Civil Procedure Rule 35(12) deals with what a joint discussion is for, and it says that the court may, at any stage, direct a discussion between experts for the purpose of requiring the experts to A, identify and discuss the issues, and B, where possible, reach an agreed opinion. The practice direction to Part 35 expands on that a little bit. It says the purpose of discussions between experts is not for experts to settle cases, but to agree and narrow issues. And in particular, that means identifying, one, the extent of the agreement between experts, two, the point of and short reasons for any disagreement, three, any action which could be taken in relation to the outstanding points of disagreement, and four, any further material issues not raised and the extent to which these issues are agreed. So there's quite a bit in there, but let's keep things simple. Really, the point of a joint discussion is to identify issues and agree them where possible. So what are the agendas? Well, it's not difficult. The practice direction says that where the experts are to meet, the parties must discuss and, if possible, agree whether an agenda is necessary, and if so, attempt to agree on one that, quote, helps the experts to focus on the issues. So again, keeping this simple, a joint discussion is just about identifying issues and agreeing them where possible. An agenda is just a document which is there to help the experts focus on the issues and nothing more. So this won't be a very law-heavy presentation. So having looked at the rules briefly, now let's get into, I think, 7 practical tips for drafting your agendas for joint discussions. The first tip is you don't always have to have an agenda. You might remember from the previous slide that the first thing the practice direction recommends the parties do is agree whether or not an agenda is necessary. And often it isn't. There are often cases where the issues are, for example, so straightforward that there is no utility in drafting an agenda. There are sometimes cases where the experts may be more than capable of preparing a statement on which the issues on which they agree and disagree without an agenda. Take, for example, condition and prognosis experts in certain cases. I also think there are some disciplines where the experts are best left to their own devices. Perhaps the best example for that might be care and occupational therapy type experts, who each prepare enormous reports itemizing various costs and expenses. To draft an agenda for that joint meeting would take ages. Actually, I find if you let the experts just get on with it, they will find a way to discuss the issues and set out their areas of agreement in a very logical way. So, number one is you don't always have to have an agenda, and you should only have one where it's necessary. I don't mind admitting that I have something of a love-hate relationship with drafting agendas. I do quite enjoy the process. By that I mean reading everybody's expert evidence and trying to distill it into an agenda. But at the same time, as counsel, we're often not given much time to do it. Typically less than 21 days to get everything sorted. So my suggestion to you would be, if you decide an agenda is necessary, start early. That means factoring in enough time, perhaps for you as solicitors to do a draft, for your barrister then to hopefully improve upon it, for your client to have a look if you think that's appropriate. If you have time for your expert to glance and comment on it. And that's all before you've even sent it to the other side, who may come back to you with revisions and re-revisions. So I think really, in practical terms, what that means is starting to draft the agenda at virtually the same time you receive the report from the other side. So number one was only do if it's necessary. Two is if it's necessary, start straight away. I'll talk briefly maybe about Wagamama's, the restaurant. I'm sorry if you've heard this one before, but most of you out there have probably been to Wagamama's, and when you sit down and you order your food, the thing that they say to you is, just so you know, our food is prepared fresh and it will come when it's ready. That means things may be out of order. And then what happens is they bring out your main courses first and your starters second. And that's okay. And it's okay because they have framed what's about to happen. If they didn't frame what was about to happen and they brought your main courses before your starters, you'd think the kitchen was chaotic and you wouldn't go back. Now, most things can be improved by good framing, and agendas are no exception. So what I think nearly every agenda needs to have is a really good preamble. Now, it's probably a good idea, and I suspect you do this already, to have a template that you then fine-tune for each and every case so that your preamble is bespoke. I thought it might be a good idea if I set out some example headings for your template preambles. So, for example, I think a preamble could include a brief background, talking about what the case is about, a heading which identifies what, if any, matters have been agreed between the parties, a section dealing with what the outstanding issues in the case are, perhaps not even in intimate detail, I then personally make a habit of including any very relevant documents. So I'm not talking about giving the experts all the records or all the statements again. I'm talking about potentially screenshotting or exhibiting a particularly relevant record or scan or guideline, if that applies in that case. I then include some standard material about the purpose of the discussion, which is what we started by talking about. I then talk about the purposes of agenda, which is again what we started by talking about. I would actually then include some reminders for the experts about how they don't have to agree on everything, but that they should give reasons where they don't. And I also remind them, lifting that subparagraph from the practice direction, that if they need further information or recommend further action, they should say so. I also talk about their role in this, which principally is not to decide facts and to give an opinion to assist the court. And then I think most helpfully, it's really important to give a pithy summary of the relevant legal tests in relation to the outstanding issues. And I think that's really important because there's no point the experts agreeing about anything if they get the test wrong. And that can happen easily, even in the simplest of cases. If they talk about breach of duty from a Bolam and Belitho context in an informed consent case, or they talk about causation from a material contribution perspective in a but-for case. So identify the correct test and spell it out in simple fashion so that they stand the best chance of being able to get either the law right or agreement where it's possible. If anybody is interested in taking a look at my template preamble, don't be shy about emailing me. But once you've done the preamble and you start thinking about what the agenda should actually say, I think you should try your level best to keep the agenda as simple and straightforward as possible. KISS principle is something that was born out of the American military, I think in the 60s or 70s. It basically stands for keep it simple, stupid. The idea is that wherever possible, complexity should be avoided in any kind of system because simplicity guarantees the greatest level of, quote, user acceptance and interaction. Now, I actually think the best way for us to keep agendas simple is to keep things structured. So if the American military said keep it simple, stupid, I'd say keep it structured, stupid. And that means compartmentalizing the case into the various issues. So you might, for example, at the beginning start by asking some questions or identifying some issues about the facts. Not that it's for them to decide facts, but they may have an opinion which can assist the court on the facts. Then you might deal with issues in relation to breach of duty. Then you might deal with issues in relation to causation and then condition prognosis. And once you've got your sections, you can then compartmentalize that further. You can, for example, under the breach of duty section, deal with each allegation separately. And if you think there are parts to each allegation, break that down. If you're really struggling and you don't know where to start, often it's a good idea just to put the pleadings in front of you. So the particulars of claim and the defence, or if it's a quantum case, the schedule and the counter schedule, and just work through the documents, trying to find areas of disagreement so that you can include an appropriately worded agenda item in your agenda. But please, whatever you do, try your best not to overcomplicate it. Once you've got your structure and you've compartmentalized the issues and you're trying to keep it simple, it is really important that you ask the right questions, or rather phrase the questions in the right way. You might remember, if you were paying close attention, that the practice direction said that questions must not be in the form of leading questions or hostile in tone. So just for the avoidance of doubt, a leading question is a question which points the person you're asking the question of towards a particular answer. Okay, so you're not allowed to ask a question like, do you agree the defendant was negligent? Instead, you should be asking non-leading questions. For example, was the defendant negligent? The simplest rule of thumb to try and remember is to just, if you can, restrict all your agenda item questions to non-leading closed questions. So that means questions which don't point them towards a particular answer and can be answered with a yes or no. In theory, every agenda should be capable of being written like that. And in theory, if the experts agreed, they could say yes or no to everything without further explanation. Obviously, if they disagree, that is when they will explain, and you don't need to keep trying to second guess what they will say. So the really important thing is don't ask leading questions. I would add to that, if possible, try and keep them closed. When you're doing all of this, I think what we sometimes do is fall into the trap of just doing things how they're usually done. This applies with a lot of what we do, pleadings and questions to experts and all the rest of it. I think agendas present us with an opportunity to be slightly creative. By that I mean experiment a little. So in certain cases, experiment with the way in which you present information to them, or you want them to present information to you. So I talked about care and occupational therapy experts before. Having a care and occupational therapy joint statement, which is just words, would be impenetrable. It would be much better if, for example, it was set out in a table. Sometimes other experts' opinions might lend themselves to that. In some cases, it might help if the experts present their information and opinion graphically. So if you're trying to understand how a particular operation was done, or what is wrong with a particular scan, don't be afraid about asking them to separately or together annotate something. Similarly, when you're being creative, you might want to experiment with when you time your agenda and joint discussion. The rules say, quote, at any stage you can have a joint discussion. I think one of the problems in a lot of cases is that the claimant has supportive evidence and the defendant has supportive evidence, and the parties need to go through the rigmarole of issuing court proceedings, cost and case management hearings, exchanging expert evidence, just to get to the point where there is a joint discussion between the experts. We're getting a lot better, I think, at having those sometimes on a without prejudice basis before we issue proceedings. But just because we've issued proceedings doesn't mean we can't fast forward the process. You might decide, for example, that you have several areas of expertise in a particular case, but that one area of expertise is particularly helpful and might inform what the other experts say. So don't be afraid to fast track one agenda and joint discussion if you think it might help the rest of the experts. Finally, when we're being creative, you might think about not just having one agenda and joint discussion. Sometimes, because the agenda wasn't good enough or the experts didn't do their job well enough, not everything has been dealt with in the joint statement. I've certainly got experience of one particular case where I didn't think the experts had dealt with the key issue well enough. So we ended up going back to a contested application hearing in Leeds, where the judge decided that she was going to order the experts to meet and prepare another joint statement dealing with a specific issue which the court specified. His Honour Judge Freeman in Newcastle has a habit at pre-trial review hearings of saying, I think that's still an outstanding issue. I want the experts to deal with it jointly within 7 days or 14 days or whatever before the trial. So when you're being creative, think about the way in which you and they can set out the information. Think about the timing of your agenda and joint station, and also think about going again, having another go where you think the circumstances call for it. And then last but not least, 7th on my list, a personal plea from me. I don't think I've seen a case where one of the experts has capitulated at the joint statement phase because of the way the agenda was drafted. So whilst, yes, cases are about winning and losing, and the joint statement phase is part of that, I don't think drafting the agenda necessarily is. I don't think the agenda phase is about winning. So I really don't like to see parties argue back and forth about what should and shouldn't be included in the agenda. Usually the issue that the parties fall out about just isn't a hill worth dying on. So my practical suggestion to you would be just try to be as reasonable as possible when it comes to drafting agendas and agreeing upon one. And try, if you can, to pick your battles, because the chances are the agenda isn't one of them. Now, if it just so happens that you cannot agree upon something in relation to the agenda, then it's also important to be reasonable in how you go about managing that disagreement. So going back and forth forever and ever and delaying the timetable probably isn't reasonable, and you might find yourself on the receiving end of some judicial criticism. There's one particular case on this called Saunders with Mrs. Justice Yip from Manchester, where she expressed some regret for the way in which the parties had dealt with things. But one of the suggestions she had was where the parties can't agree upon agendas, unfortunately, you're just going to have 2 agendas, one from the claimant, one from the defendant, side by side and numbered sequentially, that the experts will just have to work their way through. But that shouldn't be the default. You should be trying your absolute hardest to avoid that kind of situation. So, in summary, I told you this would be short. A joint discussion is an opportunity to avoid a court hearing for everybody involved. The joint statement and discussion is just a process by which the experts need to identify and agree the issues. The agenda is just about helping them do that. If you want some practical tips from me, it's 1, only do one if you think it's necessary, and it may not be. 2, start the process early, and that means straight away. 3, do a good, ideally bespoke, especially legally, preamble to help frame the agenda and the discussion. 4, keep it simple and structured, stupid throughout. 5, only ask neutral, objective, ideally closed, and definitely non-leading questions. 6, be creative in the way in which you ask questions or ask for the questions to be answered, how it's timed and how many times you do it. And 7, at all times, either when deciding whether to have a fight or managing a fight, be reasonable. And if you do all that, I suspect you'll find the process a lot less stressful and a lot more productive. So that's the end of my short practical presentation, which, as promised, was less than 30 minutes, but not as promised, wasn't closer to 15. As I said, if any of you have any questions or you want to see a template preamble, don't be shy about emailing me. I think if you go on my website profile, you'll see my email address there. So thank you very much for listening. I'm going to end the meeting and the presentation now.